Computer. Hello everyone, Mika Vauhkala, Helsinki, Finland here, and I'm with Tuukka Lampela from where?
Uh, yeah, I live at the moment at Rovaniemi, Finland. Yes, I am studying here at the University of Lapland.
Yeah,
I'm studying law. Yes.
yeah, in the Arctic Circle. So many people around the world go to see the Santa Claus in Finland, this fairy tale figure. So Tuukka is right there, and we have really interesting series coming up. So we're now opening up the case we filed to the European Court of Human Rights, me against the state of Finland on the case COVID pass. And what happened, I will tell you here for those who don't know. 2021 December, I was going to a Phaser cafe in Helsinki in the morning to have breakfast, and they were demanding the COVID pass, and I didn't have it to show them. And then they asked me to leave. And ever since I took this to the court, and all the Finnish courts have failed to uphold justice. And now, in mid-March, around, we filed a case to the European Court of Human Rights. And my lawyer is Virginie de Araujo-Retzia from Paris, France. And expert team is Doctor of Law Matti Muukkonen and Dr. Ase Malhotra from UK, and Dr. Claire Craig from UK, and Dr. Astrid Stuckelberger from Switzerland. And Tuukka Lampela, who is with me here, he has been, uh, was it Tuukka like 2023 you joined the team, or maybe autumn?
Yes. 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 It went so that your then lawyer Aki Nummelin contacted me and asked if I could assist with this case, and yeah, I have been on on the board since then. So it's yeah, I think it was 23 autumn. Yes, yes, it was
Yeah, and the real hearings in the District Court of Helsinki was in
24.
April 24, and you were there as well, uh,
Yes.
all the 3 days, and you've been helping a lot here. And we will now start going. I think this is maybe gonna be a 2 or 3 part series. The main filing we will open up to the public, and this is now accepted in the process of its examina
Examination.
examination in the European Court, and it's active, the case, and there are many interesting steps that may be coming ahead. And it was just 2 weeks, and we got this uh, information that it's now accepted to the process, and we didn't got rejected, and that's very good. And there is 738 pages altogether that Virginie was filing the court, so that's quite a thick amount of paper and documents. But Virginie's main filing, we will go now with you and share the clips anywhere, and it's gonna be really good and for the future. And we believe the human rights will win here, and the basic human rights over this COVID pass tyranny, well, that I experienced in this case. So, without further ado, or how you say, let's go. And Tuukka, you are free to share the screen so people can see it.
Yes. Wait a second.
Un momento,
Mm,
por favor.
see. Can you see it now?
Yeah, now it's here.
Okay, so so uh, maybe I should say something about the application to the European Court of Human Rights. So so they have very strict this the applicants have to follow the form very strictly, and 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 yeah, so for example, here is you can see this is well, you could say that this is this letter that we are seeing here. It's 20 pages. This has basically all the main arguments that Mika's team with the leading of Virginie has gathered, and it can be it's in the rules of the ECHR that this application or this can be at maximum 20 pages long, and probably for the comfort of listeners and viewers, I think we have to put this in 3 parts. There's lots of stuff here.
Yeah, we
And
will go the first 7 pages now in this session. So
yeah,
and we will keep it. We will close this first part there.
yeah, and for your convenience, I have put some highlights here, and yeah, so I suggest we just go forward reading this. Okay, so it starts with statement of facts, and they are approximately in chronological order. And so, okay, so if someone there, if some viewer doesn't already know, this case is about events that happened on the 10th December 21. Mika, then age 41, in good physical health and unvaccinated, unvaccinated for the COVID vaccinations, both for health and safety reasons and for religious and philosophical reasons, based on biblical scriptures, was refused entry to the Klubi Cafe in Helsinki due to the absence of a COVID-19 vaccine passport. And okay, I think at least most Finnish people remember the COVID pass, but if there are some international viewers, maybe we should say here that to get the COVID pass green, the person had to have a full course of vaccination at least 7 days prior. It depended on the time what was enough. In the beginning, it was 2 doses. I think it was 3 doses at some point, or that the person had a negative corona test within the last 72 hours, or had a laboratory confirmed COVID-19 infection dated within the last 6 months. And yeah, so
Yeah,
Mika,
I didn't have any of those. And is it okay we go a little bit back here? So on
yeah,
the top it says both for health and safety reasons I was unvaccinated. It's really interesting philosophical point here that the government was saying even in the court that Phaser, the cafe, protected me as well when they told me to leave. This is what they stated in the court. It sounds really crazy. But for health and safety reasons, I didn't take the vaccine. And there is a story of man from Helsinki whose name is here covered, but it's now submitted to the court, the official papers. I got to know his story in April 21. He took Pfizer vaccine and he got blind very soon after. Was it like 2.5, 3 hours after that? His left eye is still blind. I talked to him recently, and now it's 5 years of that already. Actually, kind of exactly because I think it happened like was it 13th or so, whatever, April the thing in 21, and I knew the risk in the vaccines, I didn't want to take it because I was healthy and I didn't want to, I wanted to play safe in that regard. And of course, I knew many other stories, but this came even to my WhatsApp. And I was going to the cafe with Mika and my friend, and he shared me this story in April, and the incident happened in December. Um, And then it's saying here for religious and philosophical reasons. So I'm a Christian, been since 1994, not the perfect one, but Christian still. And my body is the temple of the Holy Spirit, as it states in the Corinthians. And I want to honor God and honor the body. And I've been in good health all my life. Um, and I didn't want to take something that may be potentially harmful to me or alter the human genome. I don't accept that. And yeah, this is what happened there. And do you have anything to say here as a law student and coming to this case and going through this thing? Because I don't think we had this kind of discussions of these things in public TV or media really. I don't remember. What is your take on here?
Mm, sorry, what was your question?
What do you think about these main statements here in regard to in Finland when the COVID pass came? Were they talking the politicians about philosophical or religious reasons, or that people don't take the vaccine for safety and health reasons, or something like that?
No, no, there was no discussion, and well, we will come later to the expert opinions that we got, and I think we have to make at least one episode, maybe several episodes, about the expert statement of Matti Muukkonen,
Yes.
a Finnish legal scholar, uh, in my opinion, one of the top Finnish legal scholars, very active, very prolific, and he gave Mika an expert opinion, and he stated there that even in the when the this COVID pass law was in our parliament, uh, they actually didn't pay any attention to these religious and philosophical reasons that people could possibly have uh, as their reason to not get the COVID vaccines. Yeah,
Yeah.
but there was no public discussion, and uh, maybe actually because of that, there was no these topics were not considered in the legislation process. Yeah.
Yeah. Of course, there were stories online. People were talking, I'm not taking these jabs because they may cause this and that. But there wasn't like a widespread talk in the parliament or somewhere, like a real debate. Okay, you don't take that because you may get injured. And it was just a lot of shouting from both sides, I think, on social media at least. But this religious aspect was not many times it was not even in the preparation of the law at least at all. And my key point, what I told to the court in Finland was that uh, in my basic Christian faith, I think and I believe 100 million percent God would never ask any of his creatures, men or women, to take a vaccine or two to be able to get breakfast. He would never, it's not his mind, it's not his heart. He would never do that. So this was against my faith, this COVID pass at the core. And I said it to the court in Finland that this is the biggest reason. If everything else was burned away, this hurt my faith the most, the whole COVID pass here. Okay,
Yeah.
let's move on and so
Yeah.
there was
Mm,
the number three go in there.
yeah. Thanks. So, okay, let's continue with the facts. So, okay, now we have established Mika's basic reasons for why he didn't want to take the COVID vaccines, both health and safety reasons and for religious and philosophical reasons. And okay, so in order to avoid the actually very intense pressure exerted by the COVID passport, which was designed to encourage vaccination, Mika had in practice no choice but to contract the coronavirus or pay between 100 and 200 euros every 3 days. And this would have resulted in practice 1,000 or 2,000 euros a month um, if you would have wanted to participate in social and cultural life.
Quite expensive
And
to pay for quite expensive cups of coffee and croissants and breakfasts and lunches and
yes,
unbelievable.
and yes, and um, okay, so uh, Mika thought that, and actually uh, Matti Muukkonen also thought that this was financially unreasonable and effectively excluded people on low incomes or those who were unvaccinated for legitimate reasons, social life. So, and one of our main arguments also was that this legislation actually gave private entities such as Fazer restaurants the power to deny access to public places for lack of a COVID passport. So, and this should have been not possible uh, within our constitution. But okay, we'll get to that detail also more in depth later. And okay, so this exclusion uh, to get into the Fazer Cafe on 10th December 21 led Mika to bring a civil liability action against Fazer Ravintolat, Fazer restaurants, and the Finnish state to the Helsinki District Court, Helsingin käräjäoikeus, on 15 March 22, alleging unlawful discrimination and disproportionate interference with his fundamental rights protected by the European Convention on Human Rights. And actually, maybe I should say about this letter that and the application that Virginie filed this case in French. The working languages in the Court of Human Rights are English and French. So we could have filed this case in any language of the court's member states, for example, in Finnish, but if the case would have been accepted, then the case should in any case be processed in English or French.
Yeah,
So,
so we
but we
find it
made
in French, and this is an English translation, so
yes,
this is not
the,
like the really original translation. If you see any mistake here or errors, so I understand this is a translation, not made by a translation
yes,
agent.
yes, we have. I have also the original French version, but I'm not fluent in French. But
As of yet,
as of yet, yeah, yeah.
we don't
But
know. Parle-tu français? Parle.
wait. But to my understanding, this translation is done with the deep L mm, uh, application.
Yeah, yeah.
Yeah. Okay.
Let's go to next
So
page, page number two, and
yes. Okay. So Mika had the court case on the main process was at the Helsinki District Court on April 24, and the district court gave their judgment on 31st May 24, and what resulted, they dismissed the case and ordered Mika to pay about 130,000 euros, of which a part was jointly ordered to his lawyer, Aki Nummelin. And
so a little detail here, because Aki paid the 20,000 himself, but now I'm at enforcement process of which is roughly 130,000 euro. They are inviting me on this week to go to the office to talk about that. So there is an interest has been accumulating and so on. So even though the initial was 127,500, which is a lot, which is unbelievable big amount of money they put on my table. And even though my lawyer was paying that, so now it's 130 because their interest has been accumulating. It's almost 1,000 euro a month. And but we will go more into detail that later. And
yeah,
yeah, then we took
okay,
the Court of Appeal and go ahead.
yeah, then the Court of Appeal, which is in Finnish, Helsinki Hovioikeus, which dismissed the case without any reasoning, and the same happened at the Supreme Court.
Hey, can you stop
Mm,
there? There is a very interesting part is with reference to the resolutions of the Parliamentary Assembly of the Council of Europe, this PACE. So was this the declaration they made that nobody should be socially or economically punished if they don't take the vaccine for whatever reason?
yes, yes, but and actually, uh, maybe we can come back to this in more detail. For
Okay.
example, when we look at the Matti Muukkonen's expert statement, because he opened this up there well, and um, what's their meaning or their their value or their legal effect in the Court of Human Rights. I can say shortly now that these PACE resolutions, um, they are not law. They are technically not um, enforcing norms, but the Court of Human Rights has given them in practice often very much way. And these two resolutions, they gave this advice to the member states that no one should be put under pressure or discriminated, because if someone would decide not to take the COVID vaccines for any reasons, for health reasons or philosophical reasons or religious reasons. So yeah. So
It's
in
very interesting part. I remember those days when this was going on, and I had the screenshots of this declaration, even though it was not the law or norm, like you said. I had some trouble to get into some in the one place here in Helsinki, and I was showing that, and then the door opened almost right away. But then the COVID pass came, and they didn't really care about this resolution they made in this regard. It sounds very.
yeah,
It sounds like it couldn't happen, but it did. It happened. It happened.
mm,
And then the
yes.
Supreme Court. What happened with Supreme Court?
Yeah, the Supreme Court dismissed also the application without giving any reasons. And yeah, so we had tons of arguments, but we got no reasons, no reasoning. And yeah, and maybe I want to apologize our viewers at this point if we seem to not stay in focus because there's just so much stuff here that so much stuff here that uh, I think we cannot evade, missing our focus and getting derailed at some point. But we try to stay sharp here. And
Straight to the point.
yes, okay, and this was also uh, um, actually I thought earlier that we at least in theory we had this possible to complain to the administrative courts in Finland about these cases, but then again there was not at least not an efficient way to do it, and that became one of our main arguments to the Court of Human Rights, that there was basically no way to challenge the COVID legislation
Yeah,
or
and to
or
clarify
the
here,
decisions made. Yeah,
the Phaser Cafe or any restaurant or some venue like that, they could complain to this office, like a local regional office, about the restrictions put from the government. But the private people, they couldn't complain. There was no way to complain officially. You could complain on social media or protest or something, but there was no legal way to do it. And then I took this to the court, and we are still here. So this is a big, I would say, blocking to get justice in a way that it's guaranteed in the law. And this happened in Finland. So those who are following the law in your own country, wherever, just check it out. Was it possible in your country to complain um, in the administrative court about the COVID pass like a private person during the COVID times? So just check it out. But let's go on.
yeah.
Now
Okay,
we go to the
so
judge.
yes, so in my opinion, this is maybe the most heavy argument um, in this appeal to the court regarding the district court's judge Markku Saarikoski and our claims on his uh, conflicts of interest. And okay, so mm, he himself acknowledged that he had not made these declarations of his interests and secondary activities to which is a legal must for him. It's an obligation in the Finnish Act of laki sidonnaisesta sivutoimirekisteristä, this law, Finnish Act on the, what is it in English? About, yeah, the Finnish Act of a judge's interests and secondary activity. Yes. So he himself acknowledged that he had not done this um, declaration about his pardon my English, and missing words, but he didn't make this declaration about his appointment as a mediator to the what's it in English, but okay.
It's like it's working under the Ministry of Employment and Business. His part-time office, like solving different disputes, and he was appointed by the same ministry that was the main planner of the COVID pass in Finland, this Ministry of Employment and Business. And Sanna Marin, the Prime Minister of COVID time, she was saying this publicly in the summer 21 that this ministry was there. And then this Markku Saarikoski got his post soon after the COVID pass came in. And so but he failed to report this thing to this register, and he was not initially the judge in my case, but he was changed as the process was going on before the main hearings in the district court. And
Yeah, so the problem was that his appointment to be the mediator was done by this same government
branch
branch that was active in building the COVID pass legislation, and actually the Saarikoski's appointment was done at the same time on autumn 21 when the legislation was under work. So okay, and my opinion is that this fact alone wouldn't have been a problem. I think so, but the problem, it became a problem when Saarikoski didn't make a declaration of this in the official register, which is his legal obligation as a judge. And actually, I think he failed to fulfill this obligation for 3 years, I think. And actually, he gave information to this register bit by bit. But yeah, but this is, I think, this is a heavy claim which we made. We had heavy arguments, and yeah, this was acknowledged by Saarikoski and also the court.
Yeah,
and,
they admitted in black and white that that he didn't fulfill his duty there. It's admitted, and it of course weakens my trust to the court and justice in this country when I'm looking asking for justice. And Markku Saarikoski also said in writing that his income from this side job has been pretty mild, like not so high. But now, last spring, I think, or last year at least, he reported suddenly that I think it was 2022, he got like 70,000 euro from this side income. So that's not a small money when you take the main salary, main income as a district court judge. So that's not like a mild income. And that also came later. And then I made I think the police part is here coming later on. I think so.
Yeah, so maybe if
Coming later, yeah. So let's go to the point 13.
No problem. So I think it comes right after this next part. So okay, we made this claim about Saarikoski's conflict of interests, and okay, it was dismissed, and the argument was that it was tenuous, and immaterial, so that okay, no big deal. This happens. This was the district court's message, and okay, but and the Supreme Court, the Court of Appeal and the Supreme Court upheld this rejection without giving any reasoning, and afterwards.
Yeah, now comes the criminal complaint.
Yeah. So Mika, a few weeks after was it? Yeah, I think it
Yeah,
was
1 year ago. 1 year ago.
Yeah. No, actually, then maybe we have this year wrong here, because Yeah, I think also it was 25, but it's not a big deal. But yeah, you filed a
Or was it
you lodged.
24? Maybe it was,
Uh,
yeah, I don't remember. Yeah.
I'm not sure, but in any case, after the district court, um, I think it was 25. But yeah, so you made this uh, complaint requesting a police investigation, which was dismissed, uh, to my opinion, without good arguments. And then you made this complaint to the parliamentary ombudsman, oikeusasiamies, and I think it's still pending there.
It's still pending, and there is some other case or like a complaint made about this Judge Saarikoski, and it's been pending there, I think, like 2 years now, roughly around
Yeah,
ish. So, and yeah, that's interesting. And there is a new chancellors of justice in Finland actually have come in the meantime here, and Janne Salminen, who was in the court testifying in favor of the COVID pass. So that's very interesting as well as a side note. Um, but then is the number, is it a six, is
sorry,
it a
yeah,
15? Yeah,
sorry,
yeah,
I'm cutting you.
16, yeah.
Yeah, so okay, this I think this was this mm, complaint we made about this Judge Saarikoski. I think at least from the point of view of the Court of Human Rights, I think this should be the most heavy argument with your case. These are so-called processual things, not material things. But these are we have this right to a fair trial, and these facts are insulting your right to a fair trial. That's our argument here. And then you are denied hearing some key witnesses. You wanted to hear Sanna Marin, former Prime Minister of Finland, to testify regarding the legislative preparation of the vaccine passport and the failure to monitor scientific developments on vaccine efficacy, as required by the Finnish Constitutional Committee of the Finnish Parliament, the perustuslakivaliokunta.
Yeah, so
Also, you,
we would
yeah,
not be asking Sanna Marin, what do you think about the what is your opinion about COVID and so on? Just how the government monitored the scientific developments on vaccine efficacy as
mm,
required by the Constitutional Committee of Finnish Parliament, because it was a condition there that this vaccine pass is okay if it works. It's black and white there, black ink on white paper right there.
yes, and also you wanted to hear this Satu Koskela, who was a leading leading figure at the Ministry of Health and Social Affairs, sosiaali- ja terveysministeriö, and you wanted to hear her about the scientific basis of vaccination guidelines and the impact of variants such as Omicron. And these the district court refused, and gave a reasoning that there was it was not relevant, it was not necessary to hear Sanna Marin and Satu Koskela. And but that's that's not a legit argument, because uh, uh, we, we we should have had the possibility to hear what they had to say, but now the district court said that they they wouldn't have given any relevant information. But the very strong basic rule is that uh, um, uh, you should have the possibility to show any evidence, to bring any witnesses to the court you want,
Yes,
with
yes.
with the danger of, or with if you invite someone to the court, you take the risk of, paying more money. So that's, but it's a very, very strong basic rule that uh, the court should not refuse to uh, see some evidence, or they shouldn't refuse to hear key witnesses. But no, they did
And
without any good
on the
reasoning.
back of me, you see the background photo. That's the painting, the law and the citizen, and you see on the other corner there's this like a pink jacket. So that is Sanna Marin. They're showing the COVID passport in her right hand, and then she has a croissant on the left, and she's right there. And as is the judge Markku Saarikoski on the top of Sanna Marin's the judge showing the 130,000 euro bill. Just a side note here. But let's go on.
Yeah. So, okay, these were arguments regarding the procedural unfairness, this about the Judge Saarikoski and refusing to hear Mika's witnesses. And then we come to the costs. And okay, so we already mentioned that it was 130,000 euros, the original sum. But
Almost.
now,
Yeah.
yeah, and yeah, and but now with the interests, it's even after Aki paid 20,000 euros from there, it has already risen to almost 130,000 euros, and still
It's
counting.
few euros there. Yeah, yeah. It's right there.
Yeah. So okay. So
And
actually,
here is my personal financial information for all the world to see. You know, I'm 45, and as I said at the event, if I hadn't made mistakes in investing and trading, I would be a millionaire by now, but I'm not. So in the past, so there is like last year, my income, as it says, monthly net was 2,433 euro, and almost 80,000 debts uh, right there. And there is no land, there is no apartment, there is no forest, there is no stocks, there is no public shares, and stuff like that. So now the Finnish law required the Helsinki District Court to assess on its own initiative whether the legal costs were excessive for the applicant, and they have not done it. They didn't ask how is my financial situation, not in orally speaking at the court, neither by any letter. Nobody was asking anything. So now this is also before the European Court of Human Rights, where I'm asking justice from, that the court was putting these unbelievable amounts for me to pay. And if you calculate 130,000 euro net, it would require like 260,000 gross salary with the taxation in Finland. Um, so not many people, even in Finland, have 260,000 gross salary. But yeah,
yes,
do you have any thoughts on this? This is an interesting point. Virginie actually brought up when we took this to the European Court of Human Rights.
yes. We actually, um, uh, Virginia asked if we had this kind of legislation here in Finland about this. Should the courts assess about the whether the legal costs would become excessive for some parties? And actually, uh, I thought I had studied the processual legislation well, but actually in our materials there was not so much information about these legal costs. But actually, we found this. I think it coming on the next page. Um,
Can I say a little
Where,
joke
where,
here? I was saying the other day, I'm not dating anyone now. I'm a free man, but if I created a profile on a dating website right now, maybe the headline could be that woman, if you get interested, this time money is not the reason.
yeah, yes.
But yeah, let's go ahead. Let's go ahead.
Yeah. Okay. So, we have the actual sections about the law later, but at this point, it's enough to say that there is some law in the Finnish oikeudenkäymiskaari, the Act of Procedure, which has these sections there. But okay, um, when you try to verify the validity of the electronic signatures affixed to the Supreme Court's decision, we found out that this electronic signature of the Supreme Court's Judge Ari Kantor was invalid, which was actually quite surprising. And the court registry acknowledged this, and but they said that it was just a technical uh, little error that didn't have any effect in anything. But okay, maybe we can. Maybe we don't have to discuss that
Yeah,
more at
let's
this
move
point.
ahead.
Yeah, let's move on. And but the point is that, at least from Mika's opinion, this cast doubt on the validity of the decision.
Absolutely.
And
That answer should be 100% correct.
yeah, it's basically like saying that there is no signature. Yeah,
And yeah.
yeah. But okay, then you have requested a stay of enforcement, yeah, which hasn't been accepted in at any point. There's not news there. This is maybe I remind us that we are still going through the facts of the case. And okay, mm, but then we got from Matti Muukkonen, we got this observation that imposition of substantial costs without prior assessment of the claimant's financial capacity risks undermining the very essence of the right of access to the courts and reinforces the deterrent effect of such measures.
So yeah, we can
So
really say here that if the costs are so high as now the Finnish court system has put on my table, um, it's not very many uh, who could then even afford to really fight for their justice, their freedom, their basic rights in the system if this is like this way. And I
yeah,
think, I claim, I believe, I declare, I preach that absolutely that should not be the case. Absolutely no.
yeah, and actually we are coming to more uh, detailed detailed view about this. For example, these costs. We have some. Virginia has gathered some uh, cases from the European Court of Human Rights where this is mm, discussed. But okay, the mm, point here is that these facts reveal a pattern of procedural and substantive violations with the whole case. So, okay, here we are ending the facts section.
So it is
And then,
24 facts.
well, sections, yeah.
Oh yeah.
But
Yeah.
but then we are coming to this next bigger section about the alleged violations of the Convention human rights, and we are arguing that there has been violations to the right to a fair trial and violations to not being discriminated, especially regarding the right to your personal information and to religion and functions. So, okay, you are alleging a systemic violation of this Article 6, right to a fair trial, in respect of the objective impartiality of the courts, regarding Saarikoski, procedural fairness, and regarding especially the denying of key
witnesses.
Key witnesses, yes. Good. Thank you. And effective access to justice regarding, for example, this exorbitant costs. And yeah, so this Article 6 of the ECHR provides for the right to a fair trial. And yeah, so furthermore, the court has consistently held that this Article 6 requires an independent and impartial review, and in which the appearance of justice is essential to maintaining public confidence in the administration of justice.
Absolutely, absolutely.
And I think we have here. I think we have here later this separation between subjective impartiality and objective impartiality. And subjective impartiality means, for example, that you don't have an opinion or a pre-attitude to the case, and objective impartiality means, for example, that you are not controlled by outside operators, and so pardon my English, but
can I say in between? So, in my view, the Saarikoski, because he's on the payroll of this social ministry and justice, which he failed to report. No, not he's on the payroll under the branch of this Ministry of Business and Employment, who is also the key planner of the COVID pass. So how do you think that looks like for the outsider to look if a judge is getting money from working under a branch as solving disputes, and then this is just interesting also.
Yeah, yeah. So like I said earlier, I think that would have not been a problem by itself, but when we add to this the fact that Saarikoski didn't make these registrations, which was his legal obligation. But what I was trying to say earlier was that in addition to that, the judges, the courts have to be impartial. They also have to seem to be impartial. So you have to look like you are not partial. That comes straight from the Court of Human Rights case law. So yeah, so I think this is an important thing to understand. In addition to a judge not being partial, he has to also seem to be impartial. So if there is anything that gives a hint to outside observers that this judge might be impartial. These kind of things have been given significant, um, considerable significance by the European Court of Human Rights, and we are talking now about the objective impartiality, with that you are arguing that Saarikoski doesn't seem like impartial because
Yeah.
of all this.
Yeah.
Of all this, this is the main argument. And yeah, okay. So here we have it. The appearance of impartiality is sufficient to constitute a violation
Yes.
to this Article 6
And by the way, this
regarding fight.
Saarikoski, he was appointed for a 3-year period in 2021, and he was uh, given a second 3-year period after the first one ended.
Yeah, that's true.
After he was being ruling in my case, for example. So he got a 3-year more. If he had ruled in favor of the Constitution, as I claim, and I believe, the good question is, uh, would he have got this 3-year extra? Everybody
Yeah,
can think about it yourself.
yeah. Actually, we didn't even include these facts in our case, but if and when the case is getting to the courts, yeah, we should remember to raise this.
Yeah, so for the public to say, so there may come, uh, the European Court of Human Rights may now be asking things from the Finnish government, which me and my team will then respond. There may also be oral hearings coming in the European Court of Human Rights if the court so decides. So all these kind of things may happen as we go forward with the case. Um, and this is a really a big precedent potential in Europe, and the European Court of Human Rights is like a covering 46 nations and 700 million people roughly. Um, and Virginie was saying, my attorney, that to her knowledge, she told me this while I met her in Paris, that this is the only case in the COVID where this religious freedom is now on the COVID pass before the European Court of Human Rights. It's the only case there. So this is a very important for many people around.
Yes, kyllä. Okay, let's continue. So we are arguing here that this Saarikoski, he had this persistent omission to report this stuff to the register, which is a flagrant violation on the law and the legal obligations of him. And here's what I said about the subjective and objective impartiality. And yeah, so actually we already discussed most about this, so maybe we can skip most of this. If someone is interested to read this, did you actually put this already? You put this on X, I think.
All of these are on my X articles. This is even a pinned post, the main dossier on my X post. So you can read it there, and there is a link to
Mm.
this kind of a dossier, which is like a PDF outside X as well, but it's into it there, and yeah.
Yeah. So if anyone is interested to read this in more detail, please go to Mika's X
Yeah.
account. Okay, but no. Now we have concluded that there is at least very strong argument for claiming that Judge Saarikoski lacked objective impartiality.
Yes.
Okay, yes. And oh, sorry, where did I go now? Okay, so then we come again to the refusal to hear key witnesses. And actually, I don't know if we have anything more to say than we did earlier. Okay, I tried to highlight with green this either legislation or the court's opinions from several cases. So it's basically case law. And yeah, so there's several cases in the court. There have been several cases in the court where the court has analyzed that if a refusal to hear witnesses has been justified. And okay, it has to be, first of all, reasonable and proportionate without impeding the right to an effective defense and a fair examination of the evidence. So if and when the court takes Mika's case in, they have to ask these questions. And yeah, we actually got, even to this point, we got some help from Matti Muukkonen and his expert opinion. And because his statement actually proves that we had strong grounds and good reasons to hear Sanna Marin and Satu Koskela, to hear how they followed up with the science, and or how did they try to keep the science with up to date. And actually, Matti Muukkonen told us, even at the district court and now in the expert opinion, that the Ministry of Social and Sosiaali- ja Terveysministeriö, Ministry of Social and Health Affairs, refused Muukkonen's expert opinion in August 21. And
so they breached the duty to investigate under Article 31 of the Administrative Procedure Act.
Yeah,
the state
basically,
of Finland.
Basically they breached their duty to be up to date with the effects of their actions and the legislation they are producing. And they breached the state breached their positive obligation to establish a sufficient factual basis in cases of serious interference with fundamental rights. Yeah. And okay. So yeah, that was another of our main arguments. And yeah, and this is something that Virginie came up, that comes straight from the Court of Human Rights case law. For example, here you can read that the rejection of the appeal without reasons deprives the applicant of an effective remedy against the alleged violations.
Yeah.
Yeah. And okay, I think we discussed that already. And yeah, okay, then there's the exorbitant costs, and we already discussed that quite well. But if someone is interested here, we have the exact sections of the Code of Judicial Procedure, which is Finnish oikeudenkäymiskaari. So there, Chapter 21, Section 8a and 8b say that, for example, that the court shall, on its own initiative, reduce the amount of costs to be borne by a party if, having regard to the circumstances of the case, the situation of the parties, and the importance of the case as a whole, it would be unreasonable to require a party to pay the other party's costs. And it's a fact that the district courts and the courts of appeal and the Supreme Court, they didn't do this on their own initiative.
Yeah,
And
none of them. None of them.
yeah, and actually, we didn't also know about this before.
Until Virginie brought this up.
Yeah. So, but yeah, but yeah, it's good that we found this before we filed the case to the court. Yeah, better late than never. But
yeah, absolutely.
Yeah, but okay. There's in the court's case law, they have said
Maybe
that
the judges in Finland, they thought, I was in a black suit and whatever, that I'm a millionaire, that I have so big savings and cashier behind that. Just they don't want to investigate, but they should have. They should have.
Yeah. Maybe you looked like too rich or so rich. The judges didn't
Every man, when they
seem
put a
like
suit on, they look
impartial.
like they are some businessman. Any man who is putting a suit on. So, yeah. But yeah, that's not the case. That's not the case.
Yeah, but okay, in the court's case law, they have ruled that two prohibitive costs constitute a violation of this Article 6 regarding a fair trial, particularly where they deter litigants from exercising their rights. And in this discussion about human rights, basic rights, they use this phrase called chilling effect. Chilling effect. That this kind of acts. If a demonstrator gets beaten up by a police, it we can say that it has a chilling effect on the demonstrators' will to go at some later point again to a demonstration. So in a similar way, that you have got this exorbitant legal costs to be paid, we could say that this has a chilling effect on you at later time to maybe try to get to your rights against the state. So it has this deterring effect. And also at the case law, the court has said that access to a court must not be theoretical or illusory. So yeah. And Matti Muukkonen, in his expert opinion, told that imposition of substantial costs without prior assessment of the applicant's financial capacity risks undermining the very essence of the right of access to the courts. I think we said it already, but
yeah.
But okay. Okay, so Virginie's point of view was that these cumulative irregularities render the procedure on the whole incompatible with Article 6 regarding the right to a fair trial. And okay, we are now at the end of what we we're
Yeah,
going
so
to
we do this in
go.
three parts, and the next part is gonna be we will just show the next page. It's gonna
We
be
can give a teaser here. So this is quite technical stuff, but
but interesting. On the Finnish
yeah,
state failure to invoke the derogation clause, stricter scrutiny. So we will go into that in the next video, but this is the first one. And
yeah, yeah.
okay, um,
Mm,
thank you, Tuukka. Do you have anything else to say for the first 7 pages here? We've been going.
uh, no, no, I don't have, at least at the moment, anything more to comment. I think this is a let's. I think we should keep it here, leave it here, and I think we should continue
Yes,
uh, at the next video.
yes. Okay, so thank you everybody, and this will be in Mika Vauhkala YouTube channel and on my ex Mika Vauhkala. And please share around, and especially if you're like a lawyer, law student, or otherwise interested in these things, just go in and take a look because all of this we're doing now can have a big impact on many people in Europe and beyond even. So uh, yeah, we're talking about basic freedom and the law and the constitution and so on. So it's very, very important. Okay, thank you for now and see you in the next video.